Big news out of Texas, where yesterday a federal judge enjoined or blocked the Federal Trade Commission's non-compete rule from taking effect nationwide. The ruling bars the implementation of their controversial regulation from April that would have taken effect September 4th, and it would have invalidated all existing almost 30 million non-competition clauses now in effect and prohibited nearly all of them in the future. So the decision effectively maintains the status quo, meaning the FTC rule effectively didn't happen. And it actually maintains some certainty as we approach Labor Day for both employers and employees. There is some hope for people who wished the FTC rule did take effect and was not blocked by this judge. So let's talk about what started all this process, where we are now, and then what you can do moving forward. If you're new around here, I'm Scott Radigan, the founder of Functional Lawyer. We help all types of providers transition and protect their medical practices. Most of our physician clients come from the functional world, but we have integrative and personalized precision medicine physicians as well. And we've helped more than 500 directly and many more indirectly. So if you like what you see, please subscribe or follow us at Functional Lawyer for more updates like this one. Let's get into it. So in April, the FTC issued its non-compete rule, or the final rule, that would have barred the enforcement of all existing non-competes, but also would have invalidated the existing ones and prohibited future non-compete agreements. So employee rights advocates, rightly celebrated that as a win for competition and not restricting the movement, the free flow of workers. The FTC actually found in its decision that banning non-competes would increase workers' earning by at least $400 billion over the next decade. About 1 in 5 employees in America are subject to a non-compete, so 30 million people, or 20% of the workforce. But when the FTC was submitting or were seeking public comment on their proposed rule, they got more than 26,000 comments from the public. 25,000 of them were positive, or 96% of the response was positive. So they determined that the use of non-compete agreements constitutes an unfair method of competition in violation of Section 5 of the Federal Trade Commission Act. But over the summer, we had a couple of judges give conflicting rulings because within 24 hours of the FTC rule, we had an immediate lawsuit in the Northern District of Texas and some others elsewhere around the country challenging the rule. The headliner was the U.S. Chamber of Commerce in Northern District of Texas. So they were arguing that the rule is an unconstitutional delegation of legislative power. In other words, the FTC, a federal agency, part of the executive branch, shouldn't be writing rules like this that are somewhat, in their opinion, in the purview of Congress. So it's Congress's job. Initially, on July 3rd, Judge Ada Brown, in this case of the U.S. District Court for the Northern District of Texas, did issue a preliminary injunction, which would block the final rule from going into effect, but only for the people involved in that case, the plaintiffs in that case. So in effect, those plaintiffs could continue to use their non-competes well past September 4th. But this is a preliminary injunction, and so that was only temporary. Later, actually 1 week later, on July 10th, the judge in the U.S. District Court for the Eastern District of Pennsylvania, the Honorable Kelly Brisbane Hodge, agreed with the FTC's defending its decision, saying that the FTC Act expressly empowers them to make rules and regulations for the purpose of carrying out the provisions of the statute, which does include preventing unfair methods of competition. A judge in Florida last week in August just said they sided with the reasoning from the Texas court. But the big news from today, or from yesterday, more accurately, was that same judge in Texas, Judge Ada Brown, ruled in a permanent injunction that the FTC ban is unconstitutional, or in other words, the FTC lacked authority to issue substantive rules related to unfair methods of competition, including this one. So her decision makes the injunction permanent and nationwide, meaning it applies across the country. In other words, the rule will not take effect as it was intended on September 4th, and now we're back to square one. So employee rights groups are kind of dejected. Employees subject to non-competes, we're hoping that this would go through on September 4th. We have a few clients at Functional Lawyer that we're hoping for this to go through, because if you have a job at your hospital, sometimes it's prohibitive. You can't open your own practice nearby or within the radius of the non-competition agreement. So not great news for employees, but good news for employers. But here's what we can expect as a result of this ruling. So in effect, these cases will go to appeal. They will likely get to the Supreme Court, but that will take upwards of 7 years to get to the Supreme Court unless something crazy happens. So in the meantime, what do you do? There is a bipartisan bill in Congress in both houses called the Workforce Mobility Act that's been introduced, at least. It hasn't really made a lot of headway since it was introduced about 18 months ago. But the bill would significantly limit non-competition agreements across the country. So federal law, Congress can make laws. It would be arguable whether non-competition agreements are largely right now the purview of the states, but Congress could work its magic and then call it some sort of Commerce Clause jurisdiction for Congress to do that. But that is a possibility, and some optimists are suggesting that they could pass that bill as soon as they get back in session later this month. So that is a possibility. Let's not hold our breath for it. So right now, status quo, non-competition rules are continued to be enforced in states where they're enforceable. So if you have an employee agreement where you are subject to, or you're holding an employee subject to a non-competition agreement, everything still is the same. But in the meantime, we'll continue to monitor this situation at Functional Lawyer. So for more, please continue to follow us at functionallawyer.com or on YouTube at Functional Lawyer. I'm Scott Radigan. Thanks, and I'll see you guys in the next video.